Thanks for tuning in to your daily dose of quick real estate updates, local housing trends, and market data, plus tips, tools, and strategies to help you buy, rent, or invest with confidence. You're now getting ready with RealiCare Reports, powered by the innovation team, Camille and Rex. Now go grab your favorite morning breakfast, coffee or tea, and let's enjoy today's episode.
You know, usually when we talk about rules in the professional world, there's this expectation of precision. Like, it's supposed to be like engineering.
Right, yeah. Like everything is just black and white.
Exactly. You look at a compliance manual, you read the company policy, and it's like an X-ray of a broken arm.
Yeah.
You see the jagged white line, you point to it, and you say, well, there it is. That's the rule. Just don't break it.
Which, I mean, that creates a very comforting but ultimately completely false sense of security. We want rules to be binary.
We do. But then you step into the actual day-to-day reality of modern business communication, and suddenly that X-ray machine is just completely malfunctioning.
Oh, totally.
We are looking at a professional landscape that is incredibly murky, so welcome to today's deep dive. Our mission today is to explore the hidden legal landmines that are just lurking in your everyday professional communications.
The stuff you just do on autopilot.
Yeah, right, exactly. And our source material for this is a really fascinating August 2026 report from Florida Realtors. It details some eye-opening insights from their general counsel, Juana Watkins.
Yeah, she recently spoke at the Florida Real Estate Legal Summit.
And I want to point out right off the bat that while this source material is rooted in real estate, the core lesson here is universal. Whether you're running a bakery or managing a corporate IT team or just, sending a quick email from your phone.
Which we all do.
Right. What feels like a time-saving favor or a harmless social media post could actually cost you hundreds of thousands of dollars. Okay, let's unpack this, because we really have to start with this overarching problem that Watkins identifies, which is the dangerous assumption that if you aren't breaking a clear-cut rule, you're safe.
Yeah, Watkins warns that the line between conduct that is simply legal and conduct that makes you financially liable is, well, it's virtually invisible in some cases.
Right.
Because obvious misconduct is easy to spot. Like, if you steal from a client's trust account, the alarm bells go off.
Obviously, yeah.
But the real danger, the place where professionals are actually losing their livelihoods, that lies entirely in the gray areas. Because a professional's conduct is never judged by just one single entity.
Let's break that down, because I think most people assume they only have one boss or one regulator.
Right. They think, oh, I answer to the state board and that's it.
Exactly. But in the context of this report, a real estate professional's actions could be examined by the Florida Real Estate Commission. Yeah. And that's just the licensing board.
Right.
At the exact same time, that exact same action could be scrutinized by civil courts, by government agencies enforcing civil rights laws, and, by local realtor professional standards panels looking at ethical codes.
Which creates a, frankly, terrifying reality. Escaping discipline in one arena does not mean you are immune in another. You might beat the licensing fine, but you could still get hit with a crippling civil lawsuit or an ethics complaint.
I want to push back on this a little bit, or at least try to contextualize it, because it feels incredibly frustrating for anyone who's just trying to do their job. Isn't this basically like taking your driving test, passing it with flying colors, the DMV hands you your license, but then you immediately get sued because you rear-ended someone on the way home?
That is a great way to put it.
Right. Because you have the legal right to drive, the state literally says you meet the requirements, but you are still absolutely on the hook for paying for the damages to that other person's car.
Are professionals just being lulled into a false sense of security by aiming for bare minimum regulatory compliance?
If we connect this to the bigger picture, that is the exact trap of overlapping standards. Regulatory compliance is really often just about proving you meet a baseline of professional competence to the state.
Okay.
But civil liability is a completely different mechanism. It's about whether your specific actions cause financial or personal harm to a private party.
So it's not just about the rules, it's about the impact. Right. Think of it like building a house. You might get the state's permission to pour the foundation, meaning you are legally compliant at the regulatory level. But your local homeowners association can still sue you because you painted the front door the wrong shade of blue.
So you're playing by the state's rules, but you're getting penalized by the local rules.
Exactly. And what Watkins is stressing at this legal summit is that you cannot rely on a licensing board's silence as proof of your safety. The gap between being legal on paper and being liable in a courtroom, that's where lawsuits live and breathe.
Wow. Okay, that brings us to where these landmines actually detonate. We are moving out of the theoretical overlapping jurisdictions and into the practical, which is everyday public communication and advertising.
Right, the stuff everyone does every day.
Yeah. And Watkins states very clearly there is no place where the line is thinner between legal and liable than advertising.
Because advertising, by its very definition, is a broadcast. It's public. It isn't just your ideal customer looking at it. It is being heavily scrutinized by plaintiffs' attorneys who are looking for a class action lawsuit, government regulators, and most notably in the real estate world, fair housing testers.
Let's pause there, because fair housing testers sound like a term that gets thrown around a lot without much explanation.
Yeah, it does.
For the listener who isn't steeped in real estate law, what exactly does a tester do?
So testers act essentially as secret shoppers for civil rights.
Oh, wow. Secret shoppers?
Yeah, exactly.
Yeah.
They are individuals. They're often trained by fair housing organizations or government agencies who pose as potential renters or buyers. Their entire job is to gather evidence of exclusionary language or practices.
Okay, so how does that work in practice?
Well, they might call a property manager in pairs, like one with a specific accent, one without, and they'll ask the exact same questions to test for bias. Or they might simply comb through online listings looking for illegal language, even if that language seems totally benign to the person who wrote it.
Which brings us to the specific, everyday example in the report that I think will really resonate with anyone who has ever tried to streamline their business.
Oh, the rental ad example.
Yes. Think about an agent writing a rental ad. They know the Homeowners Association has a strict, overarching policy against certain criminal backgrounds.
Right.
So to save everyone some time, the agent just types "no felons" or "no criminal history" at the bottom of the listing. Watkins points out that this is a massive liability.
It's huge, because it immediately triggers allegations that your policy disproportionately excludes certain groups of people, which spirals into a fair housing issue through a legal mechanism known as disparate impact.
Hold on, for the non-lawyers listening, what exactly is disparate impact? Is that when you accidentally discriminate without meaning to?
Essentially, yes. The mechanism of the law looks at the statistical outcome, not your personal intent.
Yeah.
Even if a policy applies to everyone equally on paper, like a blanket ban on criminal history, if the statistical result of that policy disproportionately affects a protected class, you are in the gray area.
I see.
Because of historical and systemic issues in the criminal justice system, blanket criminal bans often skew heavily against specific minority groups. So by writing "no felons," you are creating a barrier that has a discriminatory outcome, regardless of what was in your heart when you topped it.
But come on, I have to play devil's advocate here on behalf of the listener.
Go for it.
Think about the daily reality of customer service. If I'm an agent and I know a family's going to get rejected by the board and I warn them up front with a "no felons" tag on the ad, I am saving them a $50 or $100 non-refundable application fee.
Right, you're trying to help.
Yeah, how is that anything other than good customer service? You're literally trying to do them a favor.
What's fascinating here is how entirely irrelevant your intentions are in the eyes of the law.
Seriously.
Yes, this is the good intentions trap. You might genuinely believe you're performing an act of excellent customer service, but civil liability laws, they don't care about the warmth of your heart. They care about barriers to entry. The courts will look at that ad and say, you just discouraged potentially protected class from even trying to access housing.
So my kindness is literally weaponized against me.
Always. When the impact is exclusionary, the fact that you were just trying to save them an application fee is not going to hold up in court. Convenience can never trump compliance.
So what's the alternative?
Well, the safer alternative Watkins suggests requires a total shift in how we communicate. Instead of saying who cannot apply, you need to explain that all applicants are subject to the exact same screening process.
Or better yet, she says, to just direct them to the person or the website that handles the association's specific application procedures. Like, don't summarize the rule, point to the process.
Exactly. That removes the exclusionary language while still achieving the goal of informing the applicant.
But there's another layer to this advertising minefield that Watkins explicitly warns about, and that's social media.
Oh, this is a big one.
We live in a world of character limits. We are writing business communications on platforms designed for quick, punchy thoughts. It's like trying to write a complex, multi-page legal disclaimer on the back of a postage stamp. It fundamentally does not work.
And Watkins does not offer a pass for that. She warns that a platform's character limit, or its visual format, does not excuse you from omitting necessary legal information.
You can't just say it didn't fit.
No, you cannot tell a judge, well, I couldn't fit the fair housing disclosure into a short tweet. The medium does not dictate the law. If a social media platform does not provide enough room for you to advertise legally, it is the wrong place for that message.
So we've established that typing a well-intentioned ad or trying to cram a message into a short social media post can get you sued.
Yep.
But what if you aren't writing the text at all? What if you are just borrowing a visual to make that post look nice? Here's where it gets really interesting, because the report details a specific horror story that moves us away from text and into visual risks.
Oh yeah, this is where we see how one tiny, localized mistake cascades into a massive financial disaster.
The report describes a business that faced a claim over just one copyrighted photograph. One picture they likely grabbed off a search engine to make a flyer or a social media post look a little more professional.
Which happens all the time.
All the time. But that single copyright claim triggered a broader, systemic review of the business's practices. And by the end of it, that one copied photo ultimately cost them over $200,000.
We really need to explain how a single JPEG turns into a $200,000 nightmare because it comes down to the legal discovery process.
Right, because the photo itself wasn't worth $200,000. It's what finding the photo allowed the lawyers to do. Think about the analogy here. This is exactly like getting pulled over by the police because you have a broken taillight.
Yes, exactly.
You think, okay, this is annoying, I'll pay a $50 ticket. But because they pulled you over, the officer gets a look in your backseat, asks to open the trunk, and finds a stolen, priceless painting hidden under a blanket.
Right, the initial infraction was minor, but it gave them the legal right to look under the hood. In civil litigation, when a copyright troll or a plaintiff's attorney files a claim over that one photo, they gain subpoena power.
Subpoena power.
Yeah, they get to ask for your emails. They get to look at your internal files to see how that photo was distributed.
And once they start pulling on that one loose thread, the whole sweater unravels. They find out your text marketing isn't compliant.
Right.
They see that your email footers are missing required disclosures. They notice your hiring practices in those emails look a little messy. One small slip-up essentially opens up your entire business operation to an invasive, incredibly expensive audit.
This raises an important question, doesn't it? It highlights the sheer geographic and systemic scale of your risk and why you cannot rely on high-level rules to protect you.
Watkins brings up this crucial point about the illusion of federal or state safety. A lot of professionals think, well, the federal government just changed their enforcement rules, so I'm safe. Or, I have a license to practice in this entire state, so I'm covered.
But a real estate license might let someone practice statewide, while local fair housing protections and enforcement procedures vary wildly from county to county or even city to city. Watkins warns, just because you can doesn't mean you should, especially when entering unfamiliar markets.
So if you are an agent who normally works in one city and you take a client just 3 towns over, you might suddenly be violating a local municipal ordinance you didn't even know existed.
And a change in federal policy does absolutely nothing to erase your liability there.
Because it's local.
Right. Because while the federal regulator might look the other way, the local city council still has their ordinance on the books, and private citizens still have the right to file civil lawsuits. The federal safety net is completely irrelevant when a local attorney is subpoenaing your emails over a copyrighted photo or a poorly worded local rental ad.
I am mentally deleting every stock photo I've ever put into a corporate PowerPoint right now.
I don't blame you.
It is terrifying to realize that a flaw in your casual, outward-facing communication acts as a Trojan horse, bringing regulators right into the heart of your business.
They know that if they find one compliance failure, one broken taillight, they are statistically very likely to find others.
So what does this all mean? We've painted a pretty stressful picture today of legal landmines, disparate impact, aggressive fair housing testers, and $200,000 photographs.
It is a lot to take in.
How does a professional actually function in this environment without just locking themselves in a room and refusing to ever send an email again?
Well, the core takeaway from the Florida Realtors Legal Summit is about shifting your internal default setting from action to inquiry. You do not need to memorize every law, local ordinance, and copyright statute.
Thank goodness, because that's impossible.
Right, that is impossible.
Watkins sums it up beautifully with a direct quote from the report. She says, "The unasked question is the dangerous question."
What you must do is learn to recognize the feeling of the gray area. You need an internal alarm system that goes off when you are about to do something purely for the sake of convenience, or when you are operating in an unfamiliar market.
Just trust that gut feeling.
Yes. When you feel that hesitation, pause. Ask for guidance before the situation escalates. The report specifically highlights resources like the Florida Realtors Legal Hotline, where members can literally call and talk through these exact scenarios, conflicting rules, advertising language, before they hit send.
Because asking a lawyer or a hotline a question today is infinitely cheaper than trying to defend yourself against a subpoena tomorrow. The unasked question is the one that costs you $200,000.
Before we wrap up, I want to leave you with a final thought to really mull over today. Think about your own daily professional life. Think about your inbox right now.
Oh, boy.
How much of your automated, unquestioned behavior, the email templates you've used for years, the casual text messages you send to clients to save them time, the random images you drop into your Friday afternoon presentations, how much of that is quietly sitting in a legal gray area right now, just waiting for the wrong person to look at it?
It really makes you reconsider everything. We started out thinking business rules were like an X-ray, a clean line of broken or not broken. But the reality is we are all swimming in incredibly murky waters. The only way to keep from drowning is to stop assuming you can see the bottom and start asking for help when the water gets cloudy.
Thank you so much for joining us on this deep dive. We will catch you next time.
Well, that wraps up today's episode of Reality Reports, where real estate meets real life. For more updates, tools, and insights that will help you buy, rent, or invest with confidence, be sure to follow, subscribe, stay connected, stay informed, and stay ready. Until next time.